entered pleas of guilty in cause numbers 230928, 232106, 232107, and 241925. All of those were theft of property with previous convictions. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
I defense judge.
State has, Judge.
And there was no agreement. This was just open to the court. Is that correct?
Yes, Your Honor.
I believe so, Your Honor. I didn't represent her at the stage where she entered the plea.
Okay.
My understanding is those
They were open. And are there any additions or corrections to the pre-sentence report?
None from defense.
Not from the state, Judge.
In addition to reviewing that, the state has filed a couple of things. One is a motion for me to run any sentences consecutively, which means obviously stacked on top of each other. And I think I could do that in, I think 2106 and 2107, maybe not, but the other ones I can. Is that,
Judge, I think,
are they different dates?
I think they're all different.
Are they?
I can verify it.
Hold on, I'm looking. Yeah, they're different dates.
Let me make sure. I think all four of them are.
They are. All right, so asking me to stack any sentences, and then he has filed a sentencing memorandum as well, in addition to a motion for me to deny discretionary jail credit. So, Mr. Kimler, if you would like, you may proceed.
Your Honor, I would just note that seems to be an aberrant practice as far as the harshness that the state is attempting to exert on this defendant, and I don't know that it stands out from the queue of other cases before this court to deserve such treatment, but it is what it is. I would just observe, first of all, regarding the state's posture on consecutive sentences and the denial of discretionary jail credit. Defense certainly has criminal history, but it's not to such an extent or degree, and the circumstances of the individual cases aren't such to the extreme degree that it would warrant accumulation, and certainly the denial of her jail credit is something that is problematic. I don't know exactly which jail credit the state is attempting to deny her, but obviously if she's been in pretrial detention on these cases, it seemed that she would be entitled to that jail credit without much controversy. On the grounds the state would be attempting to deny that, I don't know, but of course we would argue that she should receive credit as every other defendant before this court has for the jail time credit that they've done pursuant to these cases. I would note that the pre-sentence report indicates that she does have mental health history dating back to her time in the military, where she was discharged. She had a general discharge, and that there was notations there as far as the pre-sentence report that involves some mental health issues. I believe her to be mentally competent. Now, I, of course, wasn't her attorney when she entered the plea, but I would assume that she's been incompetent then as well. Although, as I said, she does have mental health history. I think that plays into her present situation with the theft cases that she has. You would note in the pre-sentence report where it's indicated that she was unable to afford the mental health treatment and the pharmacological remedies that are provided through prescriptions, and that she was self-medicating and had turned to theft in an attempt to maintain funds necessary to self-medicate. She indicates in the report that her memory indeed was impaired on 3 of these offenses, and she doesn't seem to remember